Good afternoon, everybody. My name is Nate Reitz. I'm the Executive Director of the Minnesota Sentencing Guidelines Commission. This is a orientation workshop for, it's designed, aimed particularly at the new members of the Sentencing Guidelines Commission that just joined us, but all members of the Sentencing Guidelines Commission certainly welcome. It is a public meeting within the meaning of the open meeting law, but it's not a Robert's Rules of Order meeting, if you will, because we're not going to be calling a meeting to order, taking votes, or anything like that. This is just information that staff wanted to share with you, and Chair Mitchell will not be along for this part of the meeting. So I wanted to start off by bringing your attention to the Commissioner's Handbook. This was an idea that Judge Knudsen gave us at the last meeting and really fleshed out some things that he thought would be helpful to have in a handbook for commission members to refer to those more permanent type of things that if you go back and look at just all in one place. You'll notice that it's tabbed and 3-hole punched. We do not have binders for you. Depending on sort of how your work goes, you may have a shelf full or a closet full of empty 3-ring binders. So maybe you'll find a home for this in one of those. But we're going to start by kind of going through some of the material that's in the 3-ring binders, just to kick things off here. The first part of the 3-ring binder has the charter statute. Let me just share my screen here for 1 minute. So the charter statute, just to walk you through it really quickly, and a lot of what you're going to see here is just orientation, familiarization, just so you kind of think, oh, I heard that somewhere, and you can look that up yourself. There's not going to be a test. You're not expected to know or remember all this stuff. It's just to get you kind of in the frame of mind. Oh, I think I heard that somewhere once. So the charter statute, the first part is talking about the members. It lists each one of you. Well, actually, this doesn't, because this is last year's version of the charter statute. We do have the change, but there were some changes to the membership and to appointment terms at subdivision 3. So subdivision 5 is really the meat of the statute, where it gives you the authority to promulgate sentencing guidelines. And it talks about what those sentencing guidelines are supposed to do. It talks about the legislative intent to some extent behind the sentencing guidelines, which has evolved over the years. This statute was established in 1978. The commission was formed in 1978. It did most of its work in 1979, getting the guidelines ready. And then in January 1980, which if you think about it, it was really not much time. In January 1980, the first Sentencing Guidelines Commission in the nation promulgated the first sentencing guidelines in the nation, and several other states and the federal government were either working on them at about the same time or got into sentencing guidelines after that. So that's subdivision 5. Subdivision 6 is really different, and we'll talk about staff a little bit later, but subdivision 6 is primarily staff's role in establishing a data center, really a clearinghouse and information center for the collection, preparation, analysis of basically sentencing practices. And we'll give you a presentation at the end of some of that data. Again, it's going to be a lot of data. We're not expecting to know it all, but just hopefully point out some highlights in the brief time that we have here for this orientation workshop. The next subdivision I'd like to talk about, jump down to subdivision 11, which talks about how the guidelines are changed. And some of the things we'll talk about in our work cycle and calendars are based on how subdivision 11 is written. So that's tab A, the charter statute. Tab B is the commission members and staff. So the first document shows you all the people who have sat in your chair before you sat there. And of course, some of you are sitting in new chairs. So there's not a lot of history there. We've got the new treatment or rehabilitative services provider and academic. Those are new members. And for your information, you'll see Kelly Lynn Mitchell here in the public member from 2019 to 2023, and the chair from 2019 to 2023. But she's also under this column here, the Commissioner of Corrections or designee. She's now the Commissioner of Corrections as designee. So this is the first time, just just so we understand that the Supreme Court Chief Justice also has a designee on the commission. And historically, the Chief Justice has exercised the designation authority rather than appear herself personally. And historically, that's been an associate justice, which is the case right now with Justice Moore. Historically, the Commissioner of Corrections has not exercised that designation authority. Historically, he or she has appeared on the commission personally, but given that Kelly Lynn Mitchell recently took a position as an Assistant Commissioner of Corrections, Commissioner Schnell decided to designate Kelly Lynn Mitchell as his designee. The next document here is a diagram that shows who the staff are. And I'm really excited to point out this little block here. I'm getting a little bit ahead of myself in the executive director's report, but we now have a new person hired in a new position, the research analyst supervisor senior. So that's the first time we've had a research supervisor since the dawn of the guidelines when there was a research director, a dedicated research director. By statute, that is my title, the research director, but by convention, I'm called the executive director. There used to be both positions were in effect. We still only have one executive director, but now we have at least a research supervisor. So we have somebody with some background. Some executive directors have had research background. I don't. I'm trained in law, but that's who I am. So why don't we quick go around and introduce ourselves? I'm, as I said, Nate Reitz. I come from a background in law, military law, and civilian prosecution. I was a military judge in the reserves until I retired a few years ago, and I've been at this job for over 9 years. Leah, you wanna go next and just introduce yourself?
Hi, I'm the new person, Leah Bauer, research. My title again, analyst supervisor. I've been on the job for 7 days, so I'm brand new, and I do have a background doing research and evaluation for Ramsey County Community Corrections for about 15 years. So I'm glad to be here, and it's nice to meet everyone.
Jill, you want to go next?
Sure. Hi, I'm Jill Payne. I'm also research staff. I'm a research analyst senior, and I've been with the commission for several years, but with a few little twists and turns with the state court administrator's office as well.
And let's see, Linda, you're online. Why don't you go next?
There we go. Oh, hi, I'm Linda McBrayer. I promise my video. Oh, there we go. Hi, I'm Linda. I've been with the guidelines a couple of decades working with practitioners in the applications of the policies for creating sentencing worksheets.
And Katie, you're listening in as an attendee, but I'm unmuting you. You want to just quickly introduce yourself?
Sure. I'm Kathleen Madland. I'm a research analysis specialist for the guidelines.
Thank you, Katie. All right, so we are, oh, you're muted again. Cool. All right, so that's that slide. So the next part of the Commissioner's Handbook has to do with the work plan. So let me just share that again. Go back to sharing. So basically, there's an annual cycle that's pretty much prescribed by statute. It starts in the beginning. The legislative session begins somewhere in the January 3rd through 8th time frame in odd numbered years. Even numbered years, it's not set, but you know, typically they'll start, I don't know, February maybe. I think that's what time they're starting this coming session is going to be in mid-February. But our deadline to our important deadline is January 15th, when we have an annual report to the legislature that's due. So that'll be something that'll be coming up in the next meeting or two, is looking at the annual report to the legislature prior to finally approving it, which is typically done in January. But feel free to approve it earlier than that. Something that has to be in the annual report to the legislature are any changes that the Sentencing Guidelines Commission wishes to propose for the following year. So if there are any commission initiatives that the commission wants to go into effect, then it has to put those in the report to the legislature by January 15th. And then the legislature has the entire session to do whatever they want with them. If they want to let them go into effect, they don't have to do anything. They will take effect August 1st. So some states have a little bit different of a way of doing things where it's basically a proposal to the legislature. And if the legislature likes it, they'll enact a law to put it into effect. The Sentencing Guidelines Commission in Minnesota is designed a little differently where it's proposed, and unless the legislature blocks it, it will go into effect. And by block, I mean enact the law, which effectively means that the House, the Senate, and the governor have to agree on blocking it. So it definitely gives the commission a little more authority to make changes to policy compared to some other states. So the next significant thing, and during the legislative session, staff is pretty busy. It depends how busy the legislature is. But every bill that looks like it might have a fiscal requirement, a money cost to the state, has to have a fiscal note. And for crime bills, the Sentencing Guidelines Commission staff, because we have all that data, because the state created this Clearinghouse and Information Center for Data back in 1978, we're sitting on a mountain of data, and we're able to be very helpful in terms of assessing what a particular crime might save or cost in terms of prison beds. And so we do estimates of future prison bed costs for crimes, say a penalty is being stiffened or something, that will have an impact. We'll then pass that along to the Department of Corrections that'll put a price tag on it. So that keeps us busy during the session. But as far as the commission work goes, so the legislative session ends in the second half of May. That means early June, the commission has to meet to decide what to do. Let's say there's a new crime created. Well, every crime nearly every crime is ranked by severity in the sentencing guidelines. And that's important because that determines ultimately what sentence somebody's going to get for committing that crime. And these crimes go into effect August 1st. So that creates a pretty tight window during which the commission has to make typically ranking decisions. It then has to go to a public hearing, which happens in July. Then the week after that, typically the commission meets again, makes a final decision. Often it's the same decision that they made in June. Sometimes it's different. This year we had a carjacking proposal that was made in June. And based on a lot of public comment we got, there was a decision to increase the ranking from what was proposed in June. So, and then that goes into effect in August 1st. So that's a little bit different. I said that everything had to go in the report to the legislature and it would take effect the following August. Not so for responses to what the legislature just did in the previous session. Those go into effect almost immediately, August 1st. So it's a very tight window there between June and July, and those are mandatory meetings, if you will. I know you might have vacation plans, but we really have to have a quorum during those two meetings in particular, and in the meeting to ratify the report to the legislature. So that's kind of it for what has to happen for the commission's work. But obviously, there's a lot that the commission has an ongoing duty to review the sentencing guidelines. And make sure they're appropriate. This commission also has an ongoing duty to make recommendations to the legislature, which we saw that at a recent meeting. So the commission, I'm not saying the commission doesn't have any other work to do, but these are the tight deadlines that the commission has to meet. Also, if the commission does want to make an initiative that it's going to propose in the January 15th report to the legislature to take effect the following August, often the commission has done that in the fall. So even though there's not necessarily a public hearing on the calendar in December, frequently the commission has held a public hearing in December to put a commission initiative in effect. So that's our work cycle in a nutshell. And then we have the 2023 and 2024 meeting calendars. The 2023 meeting calendar was recently changed where today we're meeting on a different day, and then next month we're also meeting on a different day. It's Wednesday the 8th. Otherwise, they're almost always Thursdays. So the next item in your, yes, sir.
Real quick, just to identify in 24, is it the June and the July meetings that are the really important work meetings
Yeah, the
prior to
June
the August
6th and July 25th. Now, the July 18th public hearing is not a red letter day. In fact, we don't even need a quorum to hold the public hearing. It's helpful, I think, to have a quorum at the public hearing. I think that helps the public hear. And you are responsible for taking into account whatever's said at the public hearing when you make your final decision in the week after. But it's June 6th and July 25th that are those mandatory days. And also I'd say January 11th, because typically that's when you approve the report to the legislature. But having said that, we now are capable of coming in remotely, so hopefully that makes it easier. We actually have not had an issue with quorum. I don't think at a single meeting since we've started the hybrid meeting format, so that's been very helpful. So tab D is meeting rules. So we generally follow Robert's Rules of Order. These were adopted in May 7th after some controversy about how a particular proposal was brought to the attention of the commission. So now there's a first reading rule. So basically, you can't just bring something to the commission and expect the commission to take action on it at the same meeting. It has to be two requirements. It has to be discussed at one of the two previous meetings, or either that proposal or something like that proposal. So it can't really be a surprise in that way. And also there has to be notice to the commission at least 7 days before the commission meeting. And typically that's when we give you the meeting materials is a week out. There has to be notice to the commission that this is going to be on the agenda as an action item. So no surprises for a proposal to modify the sentencing guidelines. And that's really just limited to a proposal to modify the sentencing guidelines. So keep that in mind. That's really it on that. Otherwise, the open meeting law is the other thing I wanted to talk about. So basically, if there's a quorum of the commission that's sitting around, so maybe you're at a conference and you look around and there's 6 other commission members. If you talk about commission material, commission topics, with the 7 of you sitting around, because that's a quorum of the commission, that's considered an open meeting, and or that's considered a public meeting under the open meeting law, and you have to follow all the requirements of the open meeting law. So don't have meetings of 7 or more unless you follow the open meeting requirements. And that applies to email conversations. So sometimes this happens where people say, hey, what do you think of this document? And did I say it right? And people will respond, and that's been held to be a violation of the open meetings law. So really, if you have something that you want the commission to know, send it to me. I will send it out to everybody else. We'll discuss it at the next meeting, but there won't be any discussion about it in between meetings because the public has the right to know what's actually happening and how decisions are being made. So if there's a subcommittee like we're talking about now, it's not necessarily going to be subject to the open meeting law because typically subcommittees don't have a quorum of the members of the commission. All right, so the next tab is member administration. So you're all considered to be public officials under the Minnesota Campaign Finance Board rules. So you are required to make a disclosure to the Campaign Finance and Public Disclosure Board. Apparently, you're supposed to do this right away, 14 days after undertaking the duties of the office. I don't know if that's typically how we actually do it, but I think that is what's required. But what's definitely required is in January, you'll get a letter from the Campaign Finance Board saying, hey, you've got to fill out the statement of financial interest. So, I mean, it's not that cumbersome, but you have to set up an account and do all this stuff. But it is a legal requirement. I joke that I don't think the Ramsey County Jail is full of people who violated the campaign finance, the public disclosure laws. But it is a legal requirement. You really do have to do it. The other thing I'd like Linda to jump in here, and that has to do with, sorry, these are all the forms from the Campaign Finance Board. That has to do with expenses. So for the public members, there are 3 of you who are public members. You are entitled to per diem of, I think it's $50 a day if you apply for it. And everybody is entitled to mileage if say you're not getting reimbursed for that or so forth. You can apply for mileage. And also, if we meet over at the Capitol, we do provide a parking code. So we typically don't reimburse for parking because we give you a parking code and you can use that code to park in a ramp. By the way, next month's meeting will be at the Capitol. I'll try to bring that up again at the executive director's report. So Linda, anything you want to say on how to fill out this form, or should we just, are the directions?
No, other than the fact that the term public was cut off by the form for the per diem, this is an Excel spreadsheet that if you would like to have a copy of this to claim your mileage or your public member per diem, please send me an email and I am happy to forward it on to you. This is an example of how it's filled out, but it is fairly intuitive and easy to do. And I believe following this are the instructions for completing a SWIFT vendor ID, which is an important part of being reimbursed. So there is also information on that. And if you have any questions, I also act as an administrative contact if you need help. So please don't hesitate to reach out.
All right, and then the last section is talking about how the, well, there's this demographic impact statement policy, which I'm not going to discuss, but it's put in there because that's a policy that the commission promulgated. And it used to be something that staff kind of did. And we brought it up to the commission when I first started this job, and they said, we'd like to be involved. So now there's a policy on how to do that. And then part G is sentencing guidelines resources. I'm not going to go into that because Linda is really going to give you a presentation right now. So Linda, why don't you go ahead and take it away.
Thank you, Nate. Let me get this pulled up here. Can everyone see that?
No.
My apologies. Well, I'm not entirely certain why.
Okay. Oh, there we go.
There we go.
Perfect. Go ahead.
How's that? Can you see it good now?
Yes, go ahead.
Thank you. My apologies. Thanks for having me to discuss these this very high level overview of the sentencing policies that practitioners are using to produce a sentencing worksheet and create a presumptive sentence. If you have any questions as we move through the slides, please feel free to stop and ask me. But if you'd like to delve more into these issues, reach out and I'm happy to meet with you to go over them. Although we publish a new guidelines each year, it is only in effect for August 1st of the current year that it goes into effect through July 31st of the following year, and will only cover offenses committed during this time. Each year, we also have to address any changes made by the courts that affect how the policies are applied. And one of the bigger ones in recent years was the Robinette decision in 2021, which determined that the changes made in 2019 to criminal history calculation should be applied for any offense that was pending sentencing, regardless of the date of that offense. Although the guidelines have 3 grids that are used depending on the type of the current offense, they all function the same. The vertical column is where the severity level of an offense is found, and the commission uses several factors when ranking an offense. Here on the standard grid, the numbers are presented in an increasing order, where the lowest ranked offenses are at severity level 1, and the highest ranked offenses, as you can see, murders, those person offenses are ranked up at the top at severity 11. We have the sex offender grid enacted in 2016, which functions the same as the standard grid, with severity levels of I for the lower level offense up through severity level A for criminal sexual conduct in the first degree, amongst other offenses. You can see along the side, there are descriptions, there are certain offenses listed. Those are examples of offenses listed, ranked at that level. The practitioners have multiple pages of severity levels depending on what the offense is that they can turn to. The drug offender grid is our last separate grid, our last separate grid that was enacted in 2016, still functioning the same way with a severity level D1 as the lowest, up through a D9. For criminal history scores, which we also sometimes refer to as the total points, those are found on the horizontal row of the grids and are given a score of 0 to 6, with a possible sentencing enhancement if the criminal history score exceeds 6 points. The calculation of these scores is comprised of a custody status point value, along with points assigned for all eligible prior felonies, misdemeanors and gross misdemeanors, and juvenile adjudications that received their imposed sentence prior to sentencing on the current offense. The calculation of points is the same for a current offense sentenced from the standard sentencing grid or the drug offender grid. But for the sex offender grid, points may be assigned higher if the prior offense under consideration was a felony that is also found on this grid. So higher points can be assigned for a prior sex offense, as well as an additional custody status point for that prior sex offense as well. Once the severity level and the total points are determined, regardless of which 3 grids are used, the presumptive sentence is found by finding the severity level of the current offense and then moving across the row to the cell corresponding with the criminal history score. For the cells that are shaded, the presumptive disposition is a stayed prison term, and the cells above the demarcation line indicate prison sentences and contain both the presumptive guideline sentence along with a 15% down and 20% up pre-calculated range for a sentence that the court can impose without departure. Policies that may affect the guideline sentence are those surrounding presumptive or mandatory minimum sentencing, which may affect either the disposition, the duration, or both. Although shaded cells do not present a range like the commit cells do, a presumptive prison disposition and a duration found in the shaded cells is also provided a range for the sentence. Sentence modifier policies will also affect the presumptive sentence by either reducing the sentence time or increasing it. These modifiers must always bear in mind any mandatory minimum set in statute along with any statutory maximum when they are calculating the presumptive sentence. A sentence outside of the grid disposition or the duration is a departure from the presumptive sentence. The court can make a mitigated departure to reduce the sentence duration or stay a prison term, or an aggravated departure to increase the months imposed on the sentence or execute a stayed sentence and impose prison. MSGC is able to determine when a departure has been imposed because the sentencing worksheet will always reflect the presumptive guideline sentence from the grid. That is then compared to the sentence imposed by the court. So we see that in this example, although the sentence called for a commit for 38 months with a range of 33 to 45, the court found compelling reasons and did a stay of execution of that prison sentence for 38 months, thereby giving a mitigated dispositional departure. Whereas this one would be an aggravated durational departure example, because the sentence was presumed to be 158 months with a range of 135 to 198. But the court found, based on this person being a career offender, that a 240-month prison sentence was appropriate. So after meeting all of the applicable legal things that need to be done when giving an aggravated durational sentence, they would file a report with us explaining the reasons why this departure was given, as would any departure require written reasons provided to the commission in a timely manner. Although staff is often asked the question, will this be a legal sentence or an illegal sentence? That is not a question that the commission can answer. Only the appellate court can make that determination. Thank you so much for allowing me to spend this time with you. I really look forward to working with you, and I hope that you'll reach out if you would like any more of a descriptive jump into any of these policies. And I'll sit for questions now if anyone has any. I'm hearing none, and I appreciate that, because sometimes it's just a matter of taking in all of this information, but I'm available if you need me. Please take care.
Thank you, Linda. Thank you. So Linda's giving you an overview of how the sentencing guidelines policies function. Now the research staff is going to give you a bird's eye view of trends and practices in felony sentencing. We do this with a view of equipping you, commission members, to make more informed decisions about what changes, if any, may need to be made to these policies. But we understand this is a lot of information, and we don't, as I said, there's not going to be a test, and we don't expect you to remember everything that's being said. So we already talked about the legislature, the charter statute, when it made the commission, it didn't just make it policy-making body. It also made this clearinghouse and information center for sentencing data. And it continues to be really staff's core mission, especially the research staff. We've been collecting data on every single felony sentence that's been passed in the state of Minnesota for 4 decades now. And we're about to share with you some highlights from our most recent completed year of data, which is 2021. So 2022 data, we're working on that. It's in the oven. You can smell it, but it's not quite ready to take out. Hopefully we'll have something for it. Actually, when we practice this, Jill surprised me by coming up with some one tidbit of 2022 data. So there's a little bit that we know already. Jill, go ahead.
Okay. All right, thanks. Okay, before we start talking about the data itself, we wanted to talk a little bit more about the process. Linda covered a lot of that, but I'll just go over a little bit more of it. The data includes people convicted of a felony and sentenced in adult court in Minnesota. The data is person-based, so what we mean by that is a person convicted of more than one offense in one county during a single month is counted once based on the most serious offense of conviction. A case begins with a sentencing worksheet, like Linda said. It's filed by probation, and it includes important demographic information and the presumptive sentence that Linda talked about earlier. Our data, the MSGC data, is then matched to the court sentence, and a departure is recorded again when the presumptive sentence doesn't match the pronounced sentence. The commission would then expect to receive a departure report within 2 weeks after sentencing in our office, and that includes the substantial and compelling reasons for departure. And Katie's going to talk a little bit more about the departure data in a bit. All right, next slide, please, Nate. There we go. Okay. So over 14,000 people were sentenced in 2021, and that is up from 11,000 in 2020, down from over 17,000 in 2019. Preliminary 22 data set shows about 16,000 cases, so this appears to be back up from the pre-pandemic numbers. As a proportion of cases sentenced in 2021, person offenses made up the largest volume. That's kind of hiding back here, that dark blue bar. And then after that, second largest volume is drug offenses. That's the light blue bar here. Okay, next slide, Nate, when you get it.
I was just thinking maybe I could move that box around.
Oh, yeah.
Uh,
The box kind of moved on us. All right. Okay, things to note on this slide are that cases were up by 25% in 2021, down by 34% in 2020. So there's this big back and forth jump. But what's important to note here is this big swing is assumed to be due to the COVID-19 pandemic and the resulting pandemic backlog of criminal cases in district courts. The courts have reported in June of 23 that the backlog is almost cleared. Thanks, Nate. Okay, this slide shows the percent change from the last slide, but this is by offense type. So things to note here are the darker shading means the higher the percent change. The blues are increases. On here, the greens are decreases. So everything for 2021 was an increase, and the highest percent change in 21 was in the weapon category. That was 33.3%. And the category includes possession of a firearm by a felon and discharge of a firearm, among other weapon-related offenses. Next slide. Thanks, Nate. Okay, this slide shows the distribution of cases by race and ethnicity. The important takeaway here is that the white percentage in the dark blue has decreased by 25 points between 1981, when the guidelines were just new, and 2009. And this was largely due to the increase in the Black percentage. Okay, this slide is similar to the last, but shows the distribution across Minnesota's 10 judicial districts. And there's a map of those districts in the back of the presentation. Key takeaways here are that those who are Black, shown in the green portion of the bar, accounted for over half the people sentenced in the 4th district. That's Hennepin County, including the city of Minneapolis, and almost half the people sentenced in the 2nd district, which is Ramsey County, the city of St. Paul. Those who are American Indian in the light blue portion of the bar make up a larger share of people sentenced in the 6th, the 7th, and the 9th districts. That includes the cities of Duluth, St. Cloud, and Moorhead. The districts with the largest share of those who are Hispanic, that's the rust color of the bar, are in the 3rd district, the 5th district, and the 8th district. So those are the cities of Rochester, Austin, Mankato, and then western Minnesota is the 8th district. And lastly, the district with the largest share of those who are Asian is the 2nd district. Again, that's Ramsey County in the city of St. Paul.
All right, so we talked about case volume, like how many cases there are. Now we're going to talk about what those sentences were. And the first element of that we're going to look at is where did the defendant go after sentencing? So the green bar and the dark blue bar, I'm going to spend the least amount of time talking here. The green bar is conditional confinement, basically local jail time where the defendant went. And then the light blue bar at the bottom being prison. The dark blue bar at the top is the sum of the green bar and the light blue bar. In other words, was somebody sent to either jail or prison? That would be the question answered by the dark blue bar at the top. And you can see that at least prior to COVID, that was pretty consistently hitting above 90%. So above 90% of felon defendants being sentenced in Minnesota he either went to prison or jail. But now I'd like to kind of zero in on those bottom two, to the light blue and then the dashed line, which we haven't talked about. The dashed line is different from all the other lines on this chart because it's not showing where people actually went. It's showing where the guidelines said they should go. So it's what did the sentencing guidelines recommend as to whether the defendant goes to prison or gets a probationary sentence of some sort. And what's really interesting about this line, I find these two to be very fascinating. So we see that the dashed line, the rust-colored dashed line has pretty steadily been increasing over the years, which means that the sentencing guidelines have been presuming that a higher and higher percentage of defendants, generally speaking, be sent to prison. I don't really know why that is. It's not clear to me that there's like any obvious policy choice that the commission has been making recently, for example, that would cause more and more defendants to go to prison. What's also interesting about that is the light blue bar at the bottom. Let me just zoom in on this. Oops, skipped ahead. So the light blue bar at the bottom has not been rising. So essentially the judicial system has been not sending defendants to prison at the same rate that the sentencing guidelines recommend that defendants go to prison. And I don't know why that is. So it's interesting to see that sort of the actual imprisonment rate has been held down by the judicial system, even though it's being, there's been the policies and the sentencing guidelines have been tending to pull it up. So in 2021, and I'll be very, very interested to see what 2022 says, because as Jill pointed out, 2022 is a little bit more of a normal year. 2020 and 2021 are kind of like, we had no idea what was really going on because COVID was influencing things. But we can see a trend there that the gap between those two is getting wider. In 2021, we saw a record high percentage of defendants being recommended for prison by the sentencing guidelines. And we also saw a record high gap between the percentage of defendants who were recommended to go to prison versus the percentage of defendants who actually did go to prison. Very, very curious to see how 2022 pans out there.
So if you go back,
Yeah.
the gap between the dotted line and the light blue line represents the departures. Is that correct?
Essentially, we'll be talking about departures more specifically, but yeah, it's a crude way of showing basically mitigated dispositional departures. And we'll see that mitigated dispositional departures, actually this next slide shows 3 records that we saw in 2021. One was the mitigated dispositional departure rate. And when we talk about mitigated dispositional departure rate, typically what we're saying is when prison was recommended. It's obviously not so interesting to talk about mitigated dispositional departures when there was no prison recommended in the first place. So, but that was a record high 45.7%, which doesn't completely correspond with the gap for reasons that are beyond the scope of this presentation. But essentially it's not surprising that would be a record high. The other record was, as I pointed out, the presumptive prison rate, which was 36.1%. Already talked about that. And then the median age of case was interesting. So that might have been a COVID factor, although that seems to have been rising as well.
Nate?
Yes.
I had a question.
Yes, sir.
Or a comment. I assume at some point, if the commission hasn't already done it, we'll look and see how much of the rise in the presumptive prison rate is correlated with the rise in criminal history scores.
Yes. Yeah, that's another factor as well that's also been rising is criminal history scores, which these are all a little bit mysterious to me. I don't quite understand why all these things would be true, but here they are. And it's not our goal to unpack any of this stuff at this point, just to kind of show you sort of big pictures and data. So these next 2 slides are talking about breaking down those numbers that you just saw, but just zeroing in on 1 year, 2021, and looking at these different groups. So male, female, then the different racial groups that we track. And then on the next slide would be the different geographical areas that we track. The 1st through 10th districts. That's typically how we describe geography. it's pretty straightforward. For those of you who aren't accustomed to speaking district, I apologize for that. We do have a map in your materials that shows where the districts are. For those who are metro-centric, the 4th is the largest district by far, is Hennepin County. The 1st is South Metro, the 2nd is Ramsey County. 10th is, well, I guess I'm not gonna, I'll let the map speak for itself. But what's really interesting is you see on both the judicial district map. So again, you've got the green bar, which is the jail. You've got the dark blue bar, which is prison. And then you also have that rust-colored line. And the rust-colored line means the same thing it did on the other, which is the presumptive prison rate. And what's interesting about this is you definitely see a variation in, again, my focus is imprisonment. The sentencing guidelines don't have that much to say about local confinement. So my focus is on this dark green bar at the bottom and then the rust-colored line above it. While you certainly see variations in the imprisonment rates by race and by geography, you see a greater variation by race and by geography in the presumptive prison rate. So the sentencing guidelines are actually giving us a greater variation in terms of what is a presumed sentence than the judicial system is giving us in terms of what is an actual sentence, if that makes sense. So just very, very interesting things to take a look at. Yes, sir.
Just a really quick question.
Yeah.
So if I'm reading this right, so I'm just focusing on the 2nd district and the 4th district.
Sure.
Does that mean that the 2nd district, what does the 95% mean versus the 74%?
So the 95.6% just means that's the percentage of people who went to some kind of, who didn't walk home after the
Okay,
sentencing
so
hearing.
more people go to prison or
Prison
confinement.
or jail, yeah.
Confinement in
Right.
Ramsey than in Hennepin is basically what that means.
That is what that means, yeah.
Okay, thank you.
So Ramsey County, they have pretty similar prison rates, but Ramsey County has a higher local jail rate. And you can see that Ramsey County's presumptive prison rate is almost 50%, but they're 48.4%, which I think is really interesting. And the second one is the 4th at 41.2%. But their actual imprisonment rates aren't that much different from the state averages. So really interesting chunks of data on these slides, I think. So now Katie's going to talk about departures.
But 70% of all felony cases sentenced received the presumptive guideline sentence. The remaining 30% received some type of departure, the majority of them being mitigated departures. So first we'll look at dispositional departures. Slide, please, Nate. There. The combined mitigated and aggravated dispositional departure rate was approximately 17%, with only 0.15% being aggravated. Effective August 1st of 2015, a sentence that is executed pursuant to a defendant's right to demand execution of their sentence is no longer considered an aggravated dispositional departure. This change has resulted in a decrease in the aggravated dispositional departure rate from previous years. When we look at only the presumptive prison cases, the mitigated dispositional departure rate was 46%. Like Nate stated, this was the highest rate seen since the guidelines went into effect. And this has been increasing over time, with 2020 having the second highest rate at 43% and 2019 having the third highest rate at 39%. The mitigated dispositional departure rate was 50% or more for the offenses displayed. Second-degree assault and failure to register as a predatory offender have statutory mandatory minimums but also statutory provisions that allow for sentencing without regard to the minimum. In all offense categories, amenability to probation or treatment were the most frequently cited reasons for departure. And the prosecutor agreed to, recommended, or did not object to the departure in 72% of mitigated dispositional departures. And in 9% of these cases, the prosecutor objected to the departure. Of the cases that received an executed prison sentence, 19% got less time than the guidelines recommended, and 3% got more time. Aggravated durational departure rates were highest for second-degree murder at severity level 10 and criminal sexual conduct in the first and second degree. At 55%, mitigated durational departure rates were the highest for first degree aggravated robbery. In 74% of mitigated durational departures, the prosecutor agreed to, recommended, or did not object to the departure, and in 6% of cases, the prosecutor objected. This slide displays both mitigated dispositional and mitigated durational departures by race, ethnicity, and gender. The mitigated dispositional departure rate is in blue. It's higher for women, whereas the mitigated durational departure rate is higher for men. When it comes to the racial and ethnic groups, the white group had a higher mitigated dispositional departure rate than the total rate, but a lower durational departure rate. The Black and Asian groups had higher mitigated dispositional and durational departure rates than the total rate. And the American Indian and Hispanic groups had lower mitigated dispositional and durational departure rates than the total rate. The mitigated dispositional departure rate by judicial district ranged from a low of 33% in the 8th to a high of 58% for the 2nd, which is Ramsey. Downward durational departures among prison cases ranged from a low of 5% in the 8th to a high of 47% in the 2nd. Note that the observed variations may be partly explained by regional differences in case volume, charging and plea practices, as well as differences in the types of offenses sentenced and the criminal history scores of those individuals being sentenced.
And this is that map of the judicial districts that we were talking about. So that really concludes what we intended to talk to you about, unless you have any questions for us about anything we presented. Otherwise, so basically what's gonna happen now is I'm going to turn off the recording in just a moment and turn this back into a practice room so the public will not see what's going on in the room, and then we'll basically have about a 7-minute break until the chair comes and convenes the meeting. All right, sounds good. We are on break.
Thank you.
Thanks, Nate.